So the next question is, what does being found ineligible mean? Suppose if a consular officer finds you are not eligible to receive a visa under the US law, your visa application will be denied and you will be provided a reason for that denial. So there can be many reasons a visa applicant could be found ineligible for a visa. These reasons called ineligibilities are listed in the Immigration and Nationality Act and other immigration laws. Some ineligibilities can be overcome either by you or the visa applicant or the US petitioner in certain immigrant visa cases. And the other ineligibilities are permanent. This means that every time you apply for a visa, you will be found ineligible under the same section of the law unless a waiver of that particular ineligibility is authorized by the Department of Homeland Security. So, what if you are found ineligible for a visa? Can you get your money back? No. The answer is no. The fee that you paid is a non-refundable application processing fee. So my next question come here is that can you reapply for a visa after being rejected? So after being found ineligible for a visa, you may reapply in the future. If you reapply for a visa, which I did, after being found ineligible, with the exception of 221G refusals, you must submit a new visa application and pay the visa application fee again. And remember, it's non-refundable. If you were to find ineligible under section 214B of the INA, you should be able to present an evidence of significant changes of your circumstances seen in your last application. Now, what is a waiver? The Immigration and the Nationality Act contains provision that may allow a visa applicant who was denied a visa for a particular ineligibility to apply for a waiver of that ineligibility. The Department of Homeland Security's adjudicates all the waivers of ineligibility, waiver and dissectionary, meaning that there are no guarantee that DHS will approve a waiver for you. If the waiver is approved, you may be issued a visa. So the next question come in here, that can every applicant who is ineligible apply for a waiver? The answer is no. So if you are found an ineligible for a visa, the consular officer will inform you that if you can apply for a waiver of the ineligibility. The following factors will determine if you apply for a waiver: whether a waiver of ineligibility is available for the particular section, whether ineligibility is available for the particular section of law you are ineligible under. You must be fully qualified for the visa that you're applied for, except for that specific ineligibility, in order to be able to apply for the waiver. And if you're applying for a non-immigrant visa, generally whether the visa consular officer who found you ineligible recommends to DHS that you received a waiver, and if you are applying for an immigrant visa, whether a waiver is available for your particular situation. For example, for a certain visa ineligibilities when applying for an immigrant visa, you can only apply for a waiver if you have a US citizen or a lawful permanent resident spouse or a parent who would endure the extreme hardship if you are not able to immigrate. So how do you apply for a waiver? If you can apply for a waiver, the consular officer at the US Embassy of the Consulate or the Consulate where you applied from will inform you how you can apply. And that's about it today. Thank you so much for coming in.